Hi, I'm Mark Reinhardt, partner and attorney at Rehberg Law Group. For half a century, Rehberg Law Group has helped thousands of people set up their estate plans and help the next generation carry out those plans with a minimum of fuss, costs, and bother. Our goal is to exceed clients' expectations by unsurpassed expertise, compassion, and advice in all facets of our practice. Congratulations! You have scheduled a meeting with me or another one of our attorneys to discuss your estate plan. The first step isn't easy. It's said about 2/3 to 4/5 of people don't have an estate plan. Perhaps they want to ensure that when they die, it will be a very sad day for everybody. In this video, I'm going to cover a few ways that you can prepare for your meeting to make it more efficient and productive. This won't cover everything, of course, but that's what your meeting is for. A little time, effort, and other things now can save a lot of time and effort later. It may even save having to make additional meetings, which often means additional cost. Soon after you made your appointment, you should have received an email with directions to our SeaTac or our Bellevue office. As you know, GPS devices don't always work, and it can be very frustrating when they don't. And changes and closures due to construction or other issues present a never-ending challenge. So please, take a look at the directions, especially if it's the Bellevue office, and print it out on a map. You'll thank us later. You'll also receive a questionnaire to complete before the meeting. You can fill it out online or print it out and complete it by hand. Either way, your response might be, "Holy cow, do I really need to fill out this entire thing? That's incredible, it's huge." Yes, please do take the time to fill it out in advance. Grab a cup of coffee or maybe your favorite beverage of choice, set some time aside and carefully work through it. Take a minute or two to browse through it. The first section calls for your and your family's names, relationships, ages, and addresses. Details are very important. Try to remember or reach out to get full middle names and birthdays. Your attorney will walk through this with you to make sure he or she understands how your relationship with them is going, how they're doing, and any special problems they might face. Is anyone struggling financially? Is a child in a divorce or maybe a bad relationship? Is a child or grandchild disabled? These answers help determine how to structure your plan for your loved ones. The second part of your questionnaire is about your current documents. Do you have an estate plan? And if so, what documents do you have? It can be very helpful if you're able to send a copy to your attorney in advance. Knowing whether you have a living trust or a will or a community property agreement, powers of attorney, and a directive to physicians, and what they will help do will help your attorney walk through and see if they accomplish your goals or not. The next part of the questionnaire is called points to ponder. Your answers here will help determine your goals, desires, and concerns. If you're worried about directly giving assets to children, a testamentary trust may be helpful. If you're concerned about a probate after your death, a living trust may be considered. If you're married and the thought that your spouse might remarry and lose assets after you die is troubling, then an "I love you, honey, but" plan can be discussed. Don't worry right now about what these terms mean. Your attorney will walk you through and explain them all during your meeting. The next section is planning notes in the questionnaire. It calls for you to begin thinking about some basic questions. First, who's in charge if you can't be? This is your agent under your powers of attorney, your executor under your will, or your trustee under your trust. It's a good idea to have a couple backups in case your first choice can't serve. For parents with young children, a key issue is who would be your children's guardian. If you're uncertain if one of your choices is willing to serve, consider reaching out and asking them in advance. Second, where do things go? Are there charities, causes, or other people that you want to remember in your will or living trust? If so, remember that full names will be needed. For charities, an EIN, or often called an employer identification number, will also be needed. It's the charity's tax ID number, and it's a good way to identify the charity, even if it changes its name later. Next, there's a section on who your advisors are and whether we can contact them to discuss your estate planning. It can be very helpful to have input from your financial planner, your accountant, or other advisor in helping put together your plan. They may be able to provide insights or information that's not known to us and you might not think about mentioning to us. Finally, boy, there's a lot of this, isn't there? There's a section calling for financial information. Mark, you say, boy, I am out of gumption, I'm out of coffee. Do I really need to fill all this out? There's a lot that this calls for. Yes, please do fill it out. I understand that this can be a challenge. It will take some time. But if you have a complete financial plan from your advisor, you can bring that instead. Otherwise, it really is critical that you take the time and provide the information about your accounts, the assets, and the basic values that they might have. This really does help your attorney understand the issues and especially decide whether estate taxes might be an issue. This can help the planning and the choices that are made going forward. Whether additional beneficiaries might be needed on certain accounts can be uncovered, and even whether a will or a living trust might be a better vehicle. Don't worry, your attorney will explain all this during your meeting. Now, it's very helpful if you can provide this questionnaire a few days before the meeting. That way, your attorney can review it in advance, look at that, and help be better prepared to help you put together a plan. Good work. You've completed your questionnaire, and at long last, the day of your meeting has arrived. Don't forget, bring along the directions and the map, and if you haven't provided it already, your questionnaire. Please make every effort to keep your appointment, or if you can't, send word as early as possible. That way, the time can be opened up for another family if there's an emergency situation. Well, okay, now you're at the meeting, you brought everything you need to bring. What should you expect at the meeting? The goal of that meeting is to have a conversation with your attorney. He or she will try to avoid as much legalese and jargon as possible and help you understand things so that you can make good decisions. The basic estate planning documents, concepts, and considerations will be explained, relating them to your situation, goals, and concerns. Doing all that, a plan can be developed. The meeting is without obligation, and at the end of your meeting, your attorney will give you a fee quote based on the documents you have chosen for us to prepare and the complexity of what you'd like us to do. You can then decide whether you want to move forward or you'd like to think about it. Thank you very much for your attention. We look forward to meeting with you.